The pro-life movement may have concluded its 49-year battle to overturn the infamous Roe v. Wade decision of 1973 and the Casey decision of 1992. But last month's Dobbs decision has opened up a new chapter in the fight for life as abortion policy now shifts to the states. It's back where it was and back where it should be, in the hands of the people. And hopefully we'll see a majority of the states that will understand what this country has historically understood, that all life is precious and worthy to be welcomed into the world and protected under our laws because it's made in the image of God. Well, here with me now to talk about what's next for the states, Carolyn McDonnell. She is a staff counsel at Americans United for Life, whose organization has a new resource out to equip states in defending life in this post-Roe world. Carolyn, welcome to Washington Watch.
Thank you so much for having me today.
I've read through your resource, and it's very well thought through. You're putting this in the hands of attorneys general at the states as well as policymakers. Explain to our viewers and listeners what's behind this and what you hope to accomplish.
We just published what we have termed the Attorney General's Playbook for a post-Roe world. And what this stems from is we've had 49 years of the Roe regime and then a multitude of years of under Casey's undue burden standard. So the question right now for litigators is what comes next, and what comes next for abortion policy and abortion litigation. So we prepared this document so that attorney generals and other litigators have a resource to know what kind of procedural arguments to make now that Dobbs has overturned Roe, and what type of arguments they should be raising in litigation.
Where are the states right now? How many are already there? How many are almost there? And how many are clearly on the other side?
It's really messy, and I think that's the best way to describe it. Dobbs returned the abortion issue to the states. So about half the states have protections either at conception or up to 5 months of pregnancy. The other half of the states seem to be on the other side, where they're allowing abortion with virtually no protections for women and unborn children. And so from there, you have to look into the laws of each state and see what types of life-affirming laws they have. And once you factor in the pre-Roe laws and also conditional laws, the situation just becomes messier.
Now, you are also tracking major life cases in the federal and the state courts across the country. And I mentioned earlier, just before we went on the air, that Mississippi, a judge in Mississippi, is allowing their pro-life law to go into effect after a suit was filed by the state's only abortion clinic. So what can you tell us about some of the more notable cases that are currently in the court system?
Definitely. So Mississippi is actually a good example. And one of our concerns right now is that since the Supreme Court has said that the federal Constitution does not protect abortion as a right, is now, unfortunately, the other side is looking at the state court systems and to see what state courts and state judiciaries will contrive a state constitutional abortion right. And so in the Mississippi case, the abortionists have actually argued that the state constitution protects abortion. And of course, we know that's just a flawed understanding of the right to privacy in their state constitution. But at the same time, this argument is popping up across the different states.
So how can our viewers, our listeners, access these resources, and how can they be helpful in this effort?
If you go to our website, which is aul.org, we have all of these resources listed publicly. Anyone can access them. And I think the best way to help out at this point is to simply educate yourself. Know what Roe said, know what Dobbs said in overturning Roe, and be able to defend life by knowing the arguments behind there. And of course, if you're on the grounds, the best way to get involved is with your local pregnancy resource center, because they are on the front lines protecting women and unborn children.
In reading through these, Carolyn, I know this was designed for attorneys general that are going to be defending the law, but there are also, I think, good arguments to be used by the policymakers, because as you mentioned, the variety of state laws that we have, all the way from conception to 5 months, this is going to be, we're going to see policy being advanced, and I think these arguments are good arguments to use in that process.
Definitely. And I think on the litigation aspect, we have to understand that in the federal courts now, Dobbs has returned us to the rational basis standard. So what that means, especially for policymakers, is as long as they put forward a legitimate interest that is rationally related to the law they're promulgating, then courts will uphold that. So we can look at legitimate interests such as maternal health and safety. We have this commonly through informed consent laws or admitting privileges laws. We also can look at the dignity of the unborn child. Dobbs recognizes that states have been really straitjacketed by Roe and then Casey in advancing their interests in protecting unborn life. And thankfully, at this point in time, they can return and put forward these legitimate interests, and most laws will be upheld when they reach the courts.
It's clearly a new day. Great resource, Carolyn. I want to thank you all for putting it out, and we'll encourage people to share that with their elected officials in states across the country as well.
Thank you very much.